This video will be focusing on the use of the good faith defence under the Trademarks Act 1995. The Act allows for a trademark owner to prohibit certain acts in relation to the use of the trademark. People who do these acts in the course of trade may be subject to trademark infringement. A person will infringe a trademark where he or she engages in such conduct, unless the goods are acquired in good faith and without awareness of a notice of prohibition. Section 122(1)(b) states that a person uses a sign in good faith to indicate the kind, quality, quantity, intended purpose, value, geographical origin of goods or services. This defence was recently considered in the Federal Court and on appeal in the case of Australia Postal Corporation and the Digital Post Australia. In the first instance, Australia Post, the applicant, issued proceedings in the Federal Court of Australia against Digital Post Australia. The proceedings were for trademark infringement and contraventions of the Australia Consumer Law. The applicant argued that the respondent's trademark Digital Post Australia infringed its registered trademark Australia Post in relation to digital mail services. In response to the infringement claim, the respondent sought to rely on the defence of good faith under section 122(1)(a) and (b) of the Trademarks Act, when the person uses in good faith the person's name or the name of the person's place of business. Further, the person uses a sign in good faith to indicate the kind, quality and quantity or some other characteristic of goods and services. Despite the applicant's infringement claim failing, the primary judge addressed the respondent's defence of good faith and found that it had used its trademark in good faith to indicate the intended purpose of its digital mail service. They did this without any desire to be associated with Australia Post or to leverage any of its brands. The applicant subsequently appealed the findings of the primary judge on the grounds that he erred in finding that the trademarks were not deceptively similar and that the respondent used its trademark in good faith. On appeal, the full court upheld the primary judge's conclusion that the marks were not deceptively similar and further addressed the adoption of its name in good faith. Members of the Digital Post Board gave evidence in respect of how its name was adopted. They submitted that the respondent's name was one of 4 shortlisted potential names which were forwarded to its solicitors for clearances and searches. Their name was subsequently selected on the basis that it was functional and descriptive. While Digital Post expressed concerns that there may be a statutory restriction on the use of the word post, in its trademark it was not concerned that the name would cause confusion between itself and the applicant. The full court accepted the respondent's evidence that it used its trademark in good faith to indicate the kind, quality, quantity, intended purpose, value, geographical origin or some other characteristic of goods or services as set out under section 122(1)(b). The court found that unlike the respondent's conduct in previous cases, there was no willful blindness to the potential for confusion on the part of Digital Post Australia. On this basis, the appeal was dismissed. The respondent is aware of the applicant's reputation provided registrability advice is sought before adopting the name. It is becoming more common in federal courts that the good faith defence is being used, applied and accepted.